it's June 23rd, and a big United States Supreme Court case came out where basically a cheerleader off campus didn't make the cheerleading team, and on Snapchat she used some expletives saying "f the school, f the team, f whatever," and she was just upset, as any 14-year-old would be. And the United States Supreme Court came back today and said, "Hey, they should not have suspended her. That was an incorrect decision." So I'm going through this case, and I immediately thought of my good friend Rebecca, teaches First Amendment. She's a former journalist, still teaches journalism. So Rebecca, introduce yourself and let's talk about this.
Yeah, so my name is Rebecca Berfanger. As Mark said, I'm I wouldn't say I'm a former journalist because I still do freelance, right? But I'm not full-time. I used to be full-time before I went to law school. I currently teach an online First Amendment class at IU McKinney School of Law in Indianapolis. I teach a media law and ethics class to undergrad journalism students at Ball State. I've been doing that since 2015. I've been teaching at McKinney since 2019. And then, and it's just something, it's always been an interest of mine because obviously as a journalism student, I would have been studying First Amendment and all the fun and interesting things that go along with that. So I'm definitely in it. And I think we were talking right before the recording, I just taught a class about First Amendment and school students. So it's like very fresh and top of mind. And all of this is just so interesting. And I think this is the first case they've had since, I think they say in the at least there was an article that said it was the first school First Amendment case they've had since, I believe, 2007 or 2008. So it's been a while since they've had one of these cases come up.
Well, Rebecca, walk us through. Schools do have a little bit more leeway with First Amendment on students than other places or other institutions. Will you kind of just walk us through, I want to say the Tinker case, but yeah, walk us through how schools have a little bit more leeway than other institutions in the first place.
Sure. So the first case, and the court references this in the opinion out today, is Tinker. And that case involves students. I'm going to maybe mess up the years, but it's late 60s, early 70s, height of the Vietnam conflict. And a group of students wanted to protest the Vietnam War, and they just wanted to wear black armbands. And ultimately, the school told them they couldn't do it before they even did it. And then they end up getting suspended. And then their case eventually makes it to the US Supreme Court. And the Supreme Court says, no, your First Amendment rights don't end at the schoolhouse. When you enter the schoolhouse door, you still have some First Amendment rights. And it also is saying that they want schools to be a place for students to have that opportunity to have some free expression, because especially, and this is all about public schools. So we'll just not think about private schools. They're their own, they're their own beast. But public schools anyway, they say they can't prevent speech from happening when it hasn't quite happened yet. And that's also goes into issues of prior restraint. And the Supreme Court typically does not like prior restraint because they don't like speech to be chilled. They want speech to be open and free. Now you might still have consequences after your speech, and I could go on, and on forever. But so that's the first major case. Following that was a case called Hazelwood, and that case involved student newspaper. In that case, they went a different direction and found that because the school newspaper was part of a school curriculum, it wasn't necessarily a public forum, that the school did have. So in that case, the journalism teacher would have to take the class newspaper up to the principal for their approval of all the rules. And ultimately, there was a newspaper that came out in May. The facts are, it's more or less, everything's obviously going to be fact specific in every case. This case, the principal said no to an article about pregnant teens, an article about students in divorce, but his reasoning for it was, I think his heart was in the right place. Like the pregnant teens, even though they weren't named in the article, he thought it would be easy enough for other students to figure out who they were. So he didn't think they'd have enough anonymity in the article. And then with the case, the story about parents getting divorced, there was more going on there as far as like maybe the parents were being put in a bad light and weren't having a chance to defend themselves. So anyway, but in that case, the court did find that yes, school principals and schools in general have a right to censor student newspapers. So that was a pretty big deal. That came out in the late 80s. And then finally, and most recently, and the name of the case is escaping me, but it's in the opinion, there was it was in Alaska. There was Olympics torch relay, and there were a group of high school students that were part of an assembly, and some kid had a big banner that said "Bong hits for Jesus." And the kid says that the bong hits for Jesus was just to get attention to be on camera. Yeah, I know, it's fun. I teach this all the time and I forget that it's actually like pretty silly. And then the other, but then the principal or superintendent or somebody, some person in authority at the school says, no, you can't have a bong hits for Jesus because you're talking about, illicit drug use. And then you're also talking about Jesus. And what does this even mean? And what do we do with this? And so the court does find that because it was a school sponsored or a school related function, it involved the school, that once again, and it involved, even though the student could say it wasn't necessarily meant to be, either anti-religion or pro-drugs or whatever, however you want to try it. But a fun, because you're a criminal attorney, this is kind of a fun footnote in the case. At the time, marijuana was legal in Alaska. And it was like, they were in like kind of this in-between period of like you could have, I think it was like up to 4 ounces or something like that. And so, but again, it was a student at a school function. So even if it's legal for adults to use marijuana at the time in Alaska, it was still not going to be allowed on school grounds. So, but ultimately the court did find that yes, the Supreme Court did find yes, they could censor speech in that case. So those are kind of the top big 3 cases. There are other ones, I'm sure, but those are the 3 big ones that at least that I teach.
Tinker case, they talk about conduct that would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. When I'm not a First Amendment scholar, but that seems to be like some sort of bar that these schools have to show before they can start saying, hey, we're going to start limiting these kids. Am I right about that?
Yeah, that's absolutely right. Yeah. So that was like the line that they drew of they can still have this right to protest. Like, yeah, as long as it's not disrupting education or other people's rights, I think is another piece of the Tinker case, because the students in that case weren't doing either of those things. They were just going to be wearing black armbands as a symbolic gesture, a symbolic speech. And so if they were to be doing something more disruptive or, throwing chairs or doing something like that may not, then you get into safety issues, and then you're also disrupting school. So yes, you're absolutely right. That's the line that they drew in Tinker.
Has there been any more recent case law? What is or is not materially and substantially interference? Anything recent? I mean, I'm trying to draw a line between this cheerleader case that we're talking about did not involve online bullying. But I mean, if students do bully other students online, schools are allowed to react to that. Am I right? Even though that's off campus?
Yeah, well, so they don't go that far in this case to necessarily say yes or no on that, but they do say this was not a bullying case. They do say that yes, it was social media, but it was her personal social media that she shared only with her close and immediate, circle of Snapchat followers. And it was somebody took a screenshot of that and shared it with, I think, their own parent, who was one of the coaches for one of the teams she was involved with. And so they do go into that and how this, yeah. So because this particular case was not actually on campus, this case was not, it was not bullying. It wasn't directed at anybody in particular. It just seemed, or at least it could be interpreted. It just was her, airing her grievances about what happened. So, but yeah, so it appears that if it was a bullying case, yes, they could do that. However, in other cases, and I couldn't cite specific cases off the top of my head, but there have been other cases involving social media or just speech in general. And the court does tend to look at, okay, well, do we have other laws already that we could be using to punish people for doing certain things that could be seen as bullying or otherwise hurting, people? And so typically speech is usually free speech tends to win out in a lot of Supreme Court cases, which and as we were talking earlier too, like this case was 8-1. So it's a pretty clear how the court ruled on it. It's not close enough that if there was a new court makeup down the road, that it would be much different than it was today.
Well, I love reading the holding, and it's like, hey, this is this is off campus. It was her private Snapchat audience. Did not identify the school, did not target a particular person. It's just, she's venting. I mean, am I right? I mean, you read this opinion. I know this only came out a few hours ago. It's 42 pages long. I
Right,
appreciate
it's for you, right?
Yeah. So,
Yeah, I'm still kind
reading
of
it.
processing it myself, but yeah, first impression though, I do think that yeah, I think you're right. I think they do definitely draw out like all those facts to explain like this in this particular case, this is how we find. Yeah, so had she been using, say, for instance, a school computer or a school, laptop or equipment or something other than I believe she was using her phone to do the Snapchat that she was posting, then I would think that that could be a different outcome possibly, because again, yeah, if she was on school property, if it was specifically addressed to other, students or something along those lines. But that wasn't the case here. Also, it does go into how schools shouldn't be considered in loco parentis 24/7, because that is just too much
Hold on,
control
back
over
up.
students.
You're using a super smart word, in loco parentis. Break it down for us. What does that mean? And you
So
said
in loco parentis is, yeah, so it's the concept that when students are in the school, at least in the school building, but that can be defined as school functions that are off campus or traveling to school related, maybe to a team sport or something like that, or a field trip, that the school basically takes over. It literally means in place of the parents. And so that is just the idea that schools are going to be in that place. So they're able to make decisions about discipline and education and things that ultimately parents would have some control over. But again, when they're in the schoolhouse confines, that's their, the school has that control over the students.
no, I absolutely love that. And I actually had to Google, how do you pronounce in loco parentis? And I had to Google it. It'll pronounce it for you. So you did it
Oh,
perfectly.
nice. Yeah.
Yeah, that's not what we deal with too often in criminal defense. You teach this stuff. Obviously, you're a lawyer. You're teaching this. You're actually a journalist. Do you think this is the right outcome? Putting you on the spot.
No, so given the facts, I do. Like, given all the facts, yeah. And this is not like legal advice, so don't. So, but if I were to choose a side on this, like if both, if the parents came to me and they're like, what do we do? Our child did this and now she can't participate in school function. She was suspended from school sports, I believe. And is this okay? Now, so first of all, I'll back up a little bit. First Amendment tends to be, and you maybe remember this from constitutional law as well, if you can remember that far back. I know it's been, we've all slept since then, since law school. But one of the things that tends to come up is it's usually kind of a last defense is going to be First Amendment. Like you're going to try to, figure out other things like, okay, the rules aren't fair, or I didn't do it or whatever, but clearly she did it. There's clear evidence, of the screenshot of her Snapchat and it's her. And she never denied, as far as I know, she never denied that she did this. So she owned it. So first of all, if I was her attorney, I'd be like, good for you. You owned it. I appreciate this. Because there's no way you're going to get out of this. So there's, all kinds of evidence. And second of all, I think given, again, that she was off campus, it was her social media, it was not using any kind of school equipment, it was not at a school function, it was like at a local convenience store or something like that, right? So it wasn't even, it wasn't like she was even like on the school like sidewalk or somewhere close enough that a teacher would have necessarily seen or heard this. So yeah, so I think there was enough distance between her and the school. And again, they do say like, if it's 24/7, this would be way too much control over students. And they do, one of the things, I put it on my Facebook, let me see if I can pull it up quickly enough, I'll read it. But one of my favorite quotes is from the majority opinion. It reads, America's public schools are the nurseries of democracy. Our democracy only works if we protect the, quote, marketplace of idea, unquote. Marketplace of ideas. This free exchange facilitates an informed public opinion, which, when transmitted to lawmakers, helps produce laws that reflect the people's will. That protection must include the protection of unpopular ideas, for popular ideas have less need for protection. So the main takeaway though is it says America's public schools are the nurseries of democracy, which I just love that phrase, because they go into that a little bit tinker as well, like how we believe students should have this opportunity, because when else are they going to have an opportunity to share ideas, good or bad, and feel like they can have that, again, if they share an opinion or they go out of, if it's taken too far, then yeah, like you and I both know there are always going to be consequences. if you have unpopular speech, but with the court, how I interpret that is the court saying like, students need this in their lives. Like they need to have this time where they can feel free to express their viewpoints, whether it's popular or unpopular. And again, this is not a bullying case. This is not, she wasn't destroying property. So it's not like she was graffitiing on the walls, her viewpoints. And they basically say, and I think it's and I might be a little incorrect in this, but I think it's in the dissent where he does talk about how she's using vulgarities and how that's like too much, man, or whatever Justice Thomas is saying in his dissent. All due respect to Justice Thomas, of course. So, but I do, and they also quote one of my favorite cases, which is it's Cohen, and that's the case where the line one man's vulgarity is another's lyric. And that's actually that's where I got my podcast title, was Another's Lyric, because it's like basically saying like, yeah, we're going to have people that are going to say or do things that we don't agree with. And again, everything she did was meant for her. Now, okay, again, backing up, she might have known on one level that this would get out there and that other people would see this beyond her personal circle of people on Snapchat. Because I think everybody now knows that even though Snapchat goes away after a while, you can still screenshot it, and that, causes its own issues down the road. But again, I do think that, I think it's the right, given the facts of this particular case, I think it was the right call.
I love the phrase nurseries of democracy, because you're absolutely right. If we don't get to exercise these rights when we're young and, we're just having fun, whatnot, we're never going to do it. And I absolutely love this case. And I appreciate you spending time talking with me about this. I know that this just came out mere hours ago. And Rebecca, if people wanted to get a hold of you, what is the best way to do so?
So they can find me on Twitter, RJ Berf. I'm also Another's Lyric is my podcast that I occasionally put things up there. I usually do interviews. Sometimes it's just me rambling on about what's going on in the world. Hopefully I'll get to do more. And because I've been teaching, I've just been focused so much on that the last few weeks, at least as far as like recording and that sort of thing. And I'm also an attorney. I do various types of legal practice that have nothing to do with First Amendment, but you could find me on my my firm website, rjberfangerlaw.com.
Well, hey, thank you so much for coming here and just talking with me about this. And the links to your website and your podcast will be in the show notes. Thank you so much, Rebecca. Right, awesome. I appreciate it.